How much did you drink? Don't tell me one drink. I'm not stupid. Ms. Wiles?
Let's go cross-face, Your Honor.
Okay, so he was arraigned on these charges, failure to pay fines and costs, and then the SoberLink positive or the interlock blows. What is he going to plead on these? Or does he want a hearing or is he going to plead?
No, he's gonna plead guilty to count 1 and 2.
Is that what you want to do, sir?
Yes.
If you plead guilty here, you could get 10 days to go the 5 on each charge. Do you understand that? And did you sign, read, and understand the advice or rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there's not going to be a hearing or a trial. Do you understand that?
Yeah.
Count 1 that you failed to pay fines and costs is ordered, balance owing 1535 as of the date of the show cause. How do you plead?
Guilty.
On count 2, to the charge that you were positive for alcohol in your interlock device on February 21, that you blew a .172 at 217, 173 at 219, 161 at 312, 139 at 313, 158 at 322, 129 at 336, 136 at 338. How do you plead?
Guilty.
Did you blow positive if with those results on your interlock?
Yeah.
And had you consumed alcohol?
Yes, sir.
How much?
Not that much is why the number thrown me off, but
Well, that's a lot. That's pretty high. How much did you have?
it was by accident. It was a liquor rep drop off of some sort
Hang on a second.
of alcohol.
Am I reading this right, Beth? 117?
Your Honor.
Now, I would believe you had 1 drink if it was 16 ounces worth of vodka. Don't come in here and tell me accidental consumption. If you don't think you consumed anything, knowing, then let's have a hearing. Got it? You got it?
Yes.
Did you knowingly consume alcohol?
Yes, sir.
I don't want to get a light up here. I'm so disappointed in you. How much did you drink? Don't tell me 1 drink. I'm not stupid. I hate to use that word, but I'll use it in this context because I'm talking about myself.
82 to 3, to be honest with you.
2 to 3 what?
Alcoholic monster. I didn't try more.
Wait a minute, slow down. Slow down. What did you drink? I don't know what you're saying, 1 or 2, and then you said an alcoholic monster?
Yes.
What in the world's an alcoholic monster? They got all these different alcohol.
Monster is an energy drink, and with many beverages, they are now creating one that contains alcohol. Your Honor.
What kind of alcohol? Kind of alcohol.
There's many different kinds. There's malt liquor, there's one vodka.
The ones that you were drinking.
I am unsure. They were delivered me by a liquor rep. Drive.
Feel intoxicated?
Sick, yeah.
No, I didn't ask you if you
Oh,
felt sick.
no.
Wait a minute, slow down. Did you feel intoxicated?
Yes, sir.
And was this at the bar?
Yes, sir.
Maybe you don't need to work at the bar, eh? I want to make sure I'm reading these results right.
Sure.
I'm not being a wise guy, but I kind of am because I don't want to hear this nonsense, Eric. You signed up for sobriety. It's not a game. It's not a game. We utilize funds that were granted to us to help people, to give you sober links, to give you all these outpatient if you needed deductibles, testing, you name it. You're just start. You signed up for a marathon. You walked 400 yards and you turn around saying it's too tough. And now you got the audacity to come in here and lie to me. Don't you know sobriety court requires honesty?
Yes, sir.
Then why would you come in here and lie to me? I don't like people lying, especially in a courtroom. We're not telling stories here. This is too important. You tried to get in a car and drive a car where you have a restricted license
Yes.
and tried to drive the car when all the test results are telling us you were drunk. This is serious, serious, serious business now. Anybody force you to plead guilty? I might have viewed this slightly differently if you came in here different and that told me the truth, but you did accident. Give me a, gosh, I must look really unintelligent.
Your Honor, if I could, on Mr. Kish's behalf,
I don't want to hear it yet. I got to vent for a second because I'm fed up with this. I'm fed up. You got no business being in sobriety court. None. Has anybody forced you to plead guilty?
There.
Please are accepted. Now you can talk, Mr.
Your Honor, when me and Mr. Kish met and spoke, he didn't indicate to me the same thing that he just told the court, that he drank a Monster, thinking it was just a regular Monster energy. I looked it up on Google. I looked at the can, the picture of the can. The picture and the design of the can, they look very similar. Now, I'm not going to put words in his mouth or try to figure out what was, in his mind. But just one thing that struck me was that I didn't even know that there was Monster energy drinks. And someone who consumes energy drinks occasionally myself, I think in his defense at least that it was possibly an innocent mistake at first. And I will represent to the court, looking at the picture here, that they're 16-ounce cans and they're 6% each. So as he just stated, if he drank 2 or 3 of them, I think that could put his BAC to the readings that were on here.
Over what course of time did you drink these 2 energy drinks?
45 minutes.
Was the rep that was promoting these, was he standing there with you while you were drinking them?
He was driving along.
So there was no hurry,
No,
and you certainly felt intoxicated.
when it all came to.
If you didn't feel intoxicated when you had a .172, then we got a bigger problem than I even thought.
Yeah, Sharon. The issue I have is he's a manager at a bar. He's meeting with a liquor rep. I find it very hard to believe that you are under the understanding that you're going to consume something that doesn't have liquor in it. It is a liquor rep. It is a person who is obviously advertising, selling, or trying to get that particular item in the bar. So that is a very hard sell for me that he didn't know that an item from a liquor rep wasn't going to have it. I'm not a manager at a bar. It's just a hard sell.
have to cover this.
Yeah.
I mean, these guys come in here and they want to tell me, I don't get it. I don't understand it. I don't get it. I don't know, man. I got through law school, for the God's sakes. I never said I was Einstein, but I'm not.
Yeah, the bigger issue at this point, and I don't think Mr. Kish maybe understands, is that the program has an obligation to inform Secretary of State that he attempted to drive a vehicle with alcohol in the system, and it is most likely going to result in them pulling his restricted license.
I'm ordering his restricted license to be pulled. You don't even have to confer with them. I want that document prepared today.
I will,
Anything you want to say? Your restricted license is to be pulled, and you are, congratulations, because I don't do this. You're going to jail today for 10 days. You got in a car and tried to start the car, and the only thing that stopped you from driving that car was the fact that it wouldn't allow you to because you had such a high VAC. And then you came in here and talked to me again like I'm 10. You're going to jail. And if you don't want to do sobriety court, just come on in, tell me next week when you get out after 10 days, we'll just give you the balance and we can be on our happy merry way. We trust in you guys. We issue these restricted licenses. We're involved in that process because we can, when we get somebody in the sobriety court, you got over 2 times the legal limit and you're trying to drive. And then you're trying to tell me you didn't know there was alcohol. Give me a break. What else do I need to do? I'm so agitated right now.
adjust the money.
I don't want to, I'm not, I'm gonna let you set up terms of payment with them right now, okay?
Yeah, sure.
What else do I have to do?
At this point, he is fine in regards to phases. I'll do the calculation with the 90 days if that's necessary.
I don't even know if I want them in here anymore, to tell you the truth. You guys sign up for this, it's serious business. You didn't come in here on an open intox, buddy. Get out of here. Have a seat in the jury box.
Under Wayne County Sobriety Court, Michigan, This matter was addressed as a post-conviction compliance proceeding arising from violations of court-ordered sobriety conditions. This case implicated Michigan probation and sobriety court enforcement provisions, including MCL 771.1 and MCL 771.4, which govern probationary supervision and authorize courts to impose sanctions for non-compliance. The defendant was also subject to ignition, interlock, and alcohol monitoring requirements enforced under MCL 257.625K and related Secretary of State regulations tied to restricted driving privileges. Sobriety court operates as a discretionary, treatment-oriented alternative to incarceration. Participants consent to heightened supervision, mandatory abstinence, financial compliance, and strict reporting obligations. Violations are evaluated under a preponderance standard, and admissions alone are sufficient to support sanctions without a full evidentiary hearing. The court determined that the defendant committed a material violation of sobriety court conditions, implicating both program integrity and public safety. The court further emphasized that truthfulness to the court is a core condition of continued participation, and that misleading statements constitute an independent basis for sanction. Pursuant to its statutory authority, the court imposed a 10-day custodial sanction, ordered revocation of restricted driving privileges, and directed notification to the Michigan Secretary of State consistent with interlock enforcement procedures. The court made clear that continued placement in sobriety court remains discretionary, and future noncompliance may result in termination from the program and imposition of standard sentencing consequences.